Mr. Ludwig?
Thank you, Your Honor. May it please the court. My name is Eric Ludwig. I represent Ms. Utzler and Ms. Riley in this appeal. We have provided a brief, as the court is aware.
No penalty for that.
This is an appeal from a final order that was entered by Judge Boyer in a partition. Interestingly, the siblings, Ms. Utzler, Ms. Riley, Ms. McCulloch, and Mr. Hackett, jointly owned property that had also been titled with their deceased mother. They couldn't agree on a sale, and Ms. Utzler and Ms. Riley commenced a partition. The parties were unable to resolve it through mediation, and so there was scheduled a final hearing for August 29th, 2013.
The parties agreed to the concept of partition, that it was not subject to partition, that it needed to be
Not subject
sold.
to partition, and during the course of that hearing, the parties agreed to abide by three-quarter vote on the sale. There was, I hate to say evidence because it wasn't evidence. Nobody was sworn, no testimony was taken, but it was discussed that the property had been listed for sale and that three-quarters vote would be acceptable to Ms. Utzler, Ms. Riley, Mr. Hackett, and Ms. McCulloch. And the court said, okay, I'll take it under advisement and I will prepare an order. And on page 25 of the transcript from that hearing, the court also said the property will get sold and we'll reserve and come back and have some sort of a hearing, evidentiary hearing about the distribution of the proceeds if in fact the parties can't agree.
Mr. Ludwig, let me stop you just for a second, because I sort of want to know what, if you were to prevail in this appeal, what remedy, what relief you want, because I get the impression from reading the briefing that the fact that there's been a sale and that some third party now owns the property is not of great concern, that you're more concerned about distribution of the money from that sale. Is that correct?
That is my client's primary view, Your Honor. The price was...
It seems to me that undoing the sale is a much bigger issue in terms of whether Humpty Dumpty's fallen off the wall.
It would be, Your Honor, and I think we would have the right to do that if we are successful on this prevail, but...
On the motion for rehearing and the exceptions to the magistrate's order, I don't see where anybody's even asked that the property be unsold or what have you. It looks to me like this is just a dispute over over a lack of awarding of the costs.
That, Your Honor, that is precisely true. My clients believe that the price...
$6,000 or $7,000 worth of costs, the costs weren't awarded. Isn't that what we're here for?
Well, there's been more than that, but yes, Your Honor.
Okay.
My client's position was that the price was fair and they don't want to visit their dispute on the ultimate purchaser. 20 days or 18 days, whatever it was, after the hearing, when the court agreed that the parties could sell a property and come back and revisit the costs and expenses, the court entered an order, 7-page order, which, and I want to read the title because the title is really interesting. Order on complaint for partition, appointing special magistrate, directing parties to execute contracts for listing and sale of subject property, when the record reflects that there already was a listing agreement, and notice of intent to impose sanctions if non-compliance with court order by parties. Somewhat intimidating title, and if you read through the order, 7 pages long, there's bold-faced type directed to my clients regarding a variety of matters leading up to the time when the sale ultimately happens. That order appoints a special magistrate, contrary to the requirements of Chapter 64 that requires motion and hearing, and contrary to Florida Rule of Procedure 1.490 that requires the consent of the parties to the appointment of a magistrate. That order also establishes or sets forth in the directions of the magistrate that the parties have to provide conclusive proof as to their cost and their expenses.
Yeah, let me stop you there, because I know that was made an issue of a couple of times, but I didn't see any case law, nor am I aware of any that discusses, I saw the argument made that this is an inappropriately high standard, that it should be only a preponderance standard, but is there any authority for that, or is the judge free to establish the parameters of the proof threshold as he did in this case?
I don't believe that there's.
Can you show me any authority?
I can't find any case law where anybody's ever used the word conclusive with respect to a civil matter and a standard for the proof.
There's no case the other way either?
No, Your Honor. Frankly, in 33 years, I've never heard anybody do that. Claim, that there needed to be conclusive proof, not even in a criminal case. In any event, a motion for rehearing was filed by trial counsel addressing those standards and a variety of other things. And the court didn't rule. Normally on a motion for rehearing, the court decides whether or not to grant a hearing, and if he decides to grant a hearing, you then have a hearing on it. But there wasn't any hearing.
Is there, I'm not sure I know the local procedure here, but, normally when you file a motion for rehearing, you try to set it for hearing. And I don't get the impression that the lawyer who filed this thing did anything to...
It does not appear that Mr. Reddish noticed it for hearing, and he clearly did not notice it for hearing. It has been my experience and the practice, at least in my county, that the motion is called to the court's attention by service, and then the court either decides to have a hearing or not. In fact, that's what the rule says on a motion for rehearing. The court determines whether or not to have a hearing. In any event, it wasn't set for hearing, and we got to the point where we got. When I got in this case...
Things went on, and the magistrate who, Partition is more or less a receiver magistrate. It's not like you refer a trial to someone. He went ahead and did all the things to sell this property. Is that right?
He listed the property for sale, but he conducted no hearings. He took no testimony, and he communicated...
But as to the sale aspect of that, the quote-unquote magistrate that is used in Partition normally, I was saying, acts more or less as a receiver for the purposes of selling the property, at least.
There are two different ways that I've seen it done over the years between the statutes and the rules. Right. Either the sale is confirmed by the court, the contract is confirmed and authorized by the court, which didn't happen here, or where the special magistrate is a receiver, the special magistrate sells it and then retains the proceeds until there can be a distribution. Right. That didn't happen here either. And so what did happen here was that the property was sold, the parties were directed by the receiver to sign deeds, and the distributions were all made, so there was no sale for the court to actually confirm, there were no proceeds for the court to make a determination of.
And nobody's filing emergency motions of any sort during that process to try to get the trial court to stop this because there's a pending motion for rehearing, that the order isn't really a final judgment.
Mr. Reddish did not do that, that's correct.
Okay.
And looking at the closing statement from the sale, I had one question, because it looks to me like what I suppose the magistrate was responsible for divvying up the proceeds, but everybody received, well, Riley received a 2/5 share, Hackett received a 1/5 share. Is it Usler? I'm sorry, I can't pronounce.
Ms. Usler.
Usler, a 1/5 share. And then McCulloch, interestingly, there was a reduction for a payoff to Citibank, and I don't know what that was for. Of $3,537 looks to have been removed from McCulloch's share. What was that about?
According to the special magistrate's determinations, there was an outstanding judgment lien.
Outstanding judgment lien?
Yes, Your Honor.
So essentially the magistrate was responsible for selling the property, distributing the funds on a 1/5, just a straight 1/5 share across the board. It just so happened that Riley owned 2/5 because I think came into possession of another 1/5. I can't remember how, but in any event,
that's... There was a 5th sibling and she bought his interest.
That's what it was, okay. And again, on rehearing or the exceptions, nobody's questioning the sale of the property. This whole thing is about the failure to award some different modicum of costs, is as best I can tell.
Costs and expenses. The court
Costs and
ordered Ms.
expenses.
Usler and Ms.
So-
Riley to pay expenses
So
related to.
what are we
The
supposed to do?
expenses being the receiver's expenses? Or
I'm sorry?
the expenses being what, the receivers? I mean, I said that, the special magistrate's
There
expenses?
are several different categories, Your Honor.
Okay.
Prior to August 29th, there were condo fees, utilities, and things related to the care and maintenance and upkeep of the joint properties.
And is it your position that those were either, or that they were not payable, or that they should have been paid in greater proportion by one family member than another?
There should have been a determination of contribution from all
Okay.
five interests to their shares.
And let me-
From August
let's-
29th.
Let's go right there for a minute. When the judge sent this matter to the magistrate, he put in the order that he looked at the costs and he was basically denying any unequal distribution. However, he said the magistrate can revisit this and take evidence if there is some such to support. Is that a fair assessment of what the court did? The court did not claim an affidavit, some receipts and an affidavit were submitted. The court looked at it and said, I can't tell where this is coming from. I'm not
Correct,
going to
Your Honor.
award it, but the magistrate can look at this if they want.
Correct, Your
I'm
Honor.
authorizing the magistrate to take another look at it.
That's correct.
And the magistrate's order comes out and says, I took a look at it, I don't buy it either, you all get 1/5, that's it, we're done. Isn't
Well-
that pretty much the way it went? And here, I'm leading to a question, which is, what are you asking? If we send this back to the trial judge, I don't see that the outcome's gonna come out any differently, or if we send it back to the magistrate, I don't know what you would have us do. And secondly, can we or should we do anything since it's already been addressed by two officers of the court and said, it's not there, let's put an end to this?
Well,
It's a
Judge
lot
Black-
there, but chew on that for a minute if you would.
It is our position, and I thought I attempted to make that clear, that under Article 1, Section 21, my clients are entitled to a judicial determination as to their financial
Okay,
claims.
so we
with
send
respect
this
to
back to Judge Boyer and say, hey, you need to put more in your order about the costs, is that what you're looking for?
We're entitled to a hearing. There was
You
never
want
a
a
hearing. There was
hearing on
never any
cost.
testimony. There was never anybody put under oath by the court or by the special magistrate. And the special magistrate's report.
How much costs are your clients claiming? How much in costs?
My recollection was about $8,000, Your Honor.
So what you're asking is that we send this back to Judge Boyer and say, look, you shouldn't send this to them. You have an obligation to hold a hearing and make a record about these $8,000 worth of costs. That's what you're asking for.
Absolutely, Your Honor.
Okay.
And with regard to Judge Boyer, I filed, Mr. Reg did not, I filed a motion to disqualify Judge Boyer,
I saw it.
as you've seen.
Based on some ex parte letter that was submitted.
There was, when I appeared for the hearing, and we get to that in a moment, but when I appeared for the motion for the hearing on the motion for rehearing, the point being to get that resolved so we had a final appealable order, I reviewed the court file and found this letter. And that seemed, and I provided it to my client, and that seemed that might have had some explanation or some effect on why we went from 3/4, and we'll revisit the amounts later, to the appointment of a magistrate. You know, this case is here not for any real economic gain, but for a point, and that is a magistrate can't be appointed without the consent, without notice, and without hearing. And there was no notice, there was no hearing, and there was no consent. A magistrate is supposed to file a report. He filed a report 85 days after the sale, and only after 2 days after the hearing on the motion for rehearing was heard by Judge Boyer, and Judge Boyer approved it on the same day that it was filed, in violation of 1.490's provisions that require a report, a record prepared by the special magistrate, and there is no record, and an opportunity to file exceptions and have those exceptions ruled upon. Article 1, Section 21 of the Florida Constitution puts final responsibility in the hands of the trial court to make determinations, not in the hands of a magistrate. And we believe the magistrate went beyond what he is lawfully entitled to do, that the magistrate
Yeah,
ought not to have
What
done.
is the authority for requiring the trial judge to conduct a hearing? Can't he just look at the evidence that's submitted and say, it's inadequate, I'm not going to award costs, now, we're gonna send this down to the magistrate and have him conduct a sale? Why can't the judge do that?
I think the case law clearly says that.
What case would you point me to?
I point the court to Little versus Little at 325 Southern Second 424, where the court held, there was a third district case in 1976 where the court held that property issues were referred to a magistrate, and the magistrate was allowed to resolve those.
Is that a divorce case?
That was a divorce case. And
Little versus Little?
Yes, Your Honor. And in that case, the district court said that the court's judicial power is not delegable to decide those issues with regard to property. I'd also cite the DeClements case, which is also a domestic case where there was no record prepared, so there was nothing for the court to make a determination on. And it was the magistrate's responsibility to prepare a record and have the evidence. We don't have any idea, my clients have no idea, what was presented to the magistrate by Ms. McCulloch or by Mr. Hackett, because there were 3 separate communications between Ms. McCulloch and the magistrate, and there's no documentation, nothing. We have nothing.
In the record, we have an affidavit from Lynn Utzler that shows paid property expenses, and it's about $3,600 worth of property expenses. Are they part of these costs that you're talking about?
Yes, Your Honor.
And tell me what you think happened to them below and what you think should happen to them.
I think there needed to be a determination of who paid the condo bills, who paid the utilities, and then it should be prorated 1/5, 1/5, 1/5 as the interests appear.
Okay.
From August 29th forward, Ms. Utzler and Ms. Riley were directed to make all those payments. Condo associations are monthly and utilities are monthly. And if you look at the closing sheet that the special magistrate filed, there weren't any condo association fees or utility charges that had to be paid, so somebody paid them. And Ms. Utzler and Ms. Riley
Just
filed
want a hearing to find out, your clients want a hearing to find out how this went down and what.
That's correct, Your Honor.
You want a hearing to find out why you weren't awarded these costs, because they were submitted to Judge Boyer. And he without a hearing, declined to award any costs. I mean, that's in his order.
And they weren't, and they were resubmitted to the special magistrate, and he had no hearing.
Right.
And no evidence was taken.
If I'm not mistaken, his report did comment on them and say that they're not recoverable. The magistrate report, as I recall, without a hearing.
There was no hearing, there was no testimony, and I don't believe that he said they're not recoverable. He said they're not sufficient.
Not
Whatever that means.
Okay.
You know, and my clients under the Constitution are entitled to have a judicial officer make that determination.
I'm letting you run over the 15 minutes a little bit here, but before you sit down, I have one final question. Is
Yes,
that the order of September 18th, the one that there was a motion for rehearing on,
Yes,
can we
sir.
tell from the record who actually prepared that order and whether the parties had an opportunity to look at its contents before it was entered?
You can't tell that from the record, Your Honor.
Okay. All right, thank you.
I mean, it was signed and served by Mr. Reddish.
Okay. Are you Miss McCulloch?
I'm Miss McCulloch.
Okay. You've got time to talk to us about this, and I realize for a pro se person that's a difficult thing, and we try to keep the arguments within what the evidence is that's in the file in front of us and the like, but you're free to give us your position on this to the best of your ability. So.
I'd just like to say a couple of things. I think I was accused of, you used the word scurrilous meetings, and things of that with the magistrate and with Judge Boyer, and none of that occurred. No, there weren't any meetings with the magistrate, separate meetings, separate conversations or anything. In my answer brief, I documented every single thing involving the history of Mother's condo. And immediately after Mother died, my sister Leanne wanted to purchase the condo and hired attorney Reddish to represent her. So from the time of Mother's death in July of 2012, and with attorney involvement with attorney Reddish, all the expenses had to be paid, the utility bills, the maintenance fees, and all of that, while Leanne was determining, her legal way to purchase the condo.
Was anyone actually living in the condo after?
No, it was vacant.
It was a vacant building.
Vacant.
Okay.
They live in Orlando, and the condo's in Clearwater, right by my house.
Did I understand correctly that you were actually paying these things, but you were being paid $2,000 a month?
Okay, I used to work at Largo Police Department, and I was laid off. And when Mother became terminally ill,
Well, that was for taking care of your mother.
yeah, I took care of my mother, and I used my retirement money to take care of her. I wasn't given a dime. And,
Yeah, I'm just trying to get a handle on.
okay.
I think we're kind of boiled down to these costs that are being claimed by opposing counsel here. What do you?
Okay,
can you
I'm just
address-
saying that a lot of the months that when they were trying to purchase the condo,
Right.
all those expenses had to be paid.
Right,
And my sister was indeed paying that money.
because she was trying to buy it.
Right, because they were planning on buying it, and then, when we went to a hearing with a mediator, he said that she should continue paying, and no, I'm sorry, that my brother Don would be paying. So Don and I paid cash, and my brother took over payments. And also I was owed $2,000 from taking care of my mother. And my sister, upon my mother's death, I had an account that was also it was my mother's name and my sister's name. And per the will, it said if anything's in anyone's specific name, they shall have that. So my sister closed the account and took another $2,300 of mine. So all I'm saying is that they did pay some expenses. I paid some expenses. My brother paid some expenses. And that money was taken from me, but yet she's claiming that she paid those expenses.
Mm-hmm.
So I've been out a lot of money, and yet they want to be reimbursed. They're the ones. My brother and I already listed Mother's condo prior to when they served me that there was going to be a legal suit.
Mm-hmm.
Our portion of the condo was already listed, so I think that all of these legal proceedings was rather frivolous. Mom and Grandpa's money didn't need to be spent on this. We already agreed that we wanted to sell it, but it's like they kept putting pressure on us and making demands, and now they want money that is actually my money, a lot of my money that I lost. So.
Well, it's not inconceivable, if I'm listening to this right, that if there were a hearing in front of a circuit court judge, that you might get reimbursements that you didn't receive before.
Right. And I also think.
Are you kind of taking the position that, look, they paid some, I paid some, let's just call it a day and get closure on
I
this?
kind of like to get a little money back, but I'm kind of happy.
You
I'm kind of happy that I broke down the condo. I did all the physical work. I took care of Mother when she was dying and all of that. And it just seems like I'm happy it's all over and Mom's in a good place and all of that. But it seems like they keep bringing on attorneys and spending more money, and it's all unnecessary. And this is not what my mother would have wanted. And it just seems, and they're picking on Judge Boyer, and there were court delays, times that they didn't even show up for court appearances. all of this went on and on and on. And they wanted to change real estate contracts. They wanted to put, my brother and I were not the delay. And now they want to be reimbursed for attorney's fees and use my money. And it just seems so unfair. And I know I'm taking up your time and you're very busy.
This is your time. ma'am,
Okay,
so.
all right, but I don't think Judge Boyer should be picked on because he had this case for so long in his court. And I know, I've worked in law enforcement, I know that he's booked. He's booked and he's tired of the same thing over and over. And then sometimes my sister's not even showing up, everybody's there, but Attorney Reddish couldn't do anything because Judge Boyer would ask questions, so then they had to be detained again. And he was tired of it all, so finally he gave it to the magistrate. The magistrate did his due diligence, and I'm fine, it's all done. You know, let Mom rest in peace, and that's that. I don't have anything.
Okay, all right, thank you very much. Mr. Ludwig, you have anything you need to say in reply? You only have a couple minutes
Yes, Your Honor,
here.
I just, first of all, as the court recognized, some of the things that Ms. McCulloch has been talking about are not part of the record. But I would refer the court to Lackner versus Central Florida Investment, 5th DCA case from 2009, where Magistrate Glad was given the right to conduct a trial, and in fact, he conducted a trial, and the 5th District Court of Appeals said, can't do it. 5th District Court of Appeals in 14 Southern 3rd, 1050, said that a trial judge is the only officer with the organic right to determine the case. And, that's what we're faced here for. We're here on a principle, not just the few $1,000s to be accumulated, but that we have a trial judge who never held a hearing, never took any evidence, gave a case to a special magistrate without the consent of the parties, without the motion of the parties, in violation of Chapter 64, in violation of Florida Rule of Procedure 1.490, the sub-paragraphs, and then ultimately blessed what the magistrate did on the same day that he filed a report that contains no record, also in violation of 1.490.
Okay, thank you. The court's going to take about a 10-minute break. When we come back, we'll pick up with our 11 o'clock docket. The first case is American Bible College versus Randall. Thank you.
So are we done?
You're done. You're free to leave. Thank you.